Hello everyone, welcome to Analog IAS. Today's topic is anti-defection law. In politics, a person is said to be a defector if he changes his allegiance from one political party to the other. The 52nd Amendment Act 1985 provided for disqualification of both members of parliament and state legislatures on the grounds of defection. It also added 10th schedule to the constitution. Also, according to 91st Amendment Act 2003, the provision of 10th schedule relating to exemption from disqualification in case of split by one-third members of legislature party has been deleted. Now let us see some of the provisions of this act. A member of the house can be disqualified on two grounds. One, if he voluntarily gives up his membership of such political party, and two, if he votes or abstains from voting in a house contrary to any direction issued by his political party without obtaining prior permission of that party. Next, an independent member of a house becomes disqualified if he joins any political party after the election. Next, a nominated member of a house becomes disqualified if he joins any political party after the expiry of 6 months from the date on which he takes his seat in the house. But there are some exceptions to this law. They are: 1. If a member goes out of his party as a result of merger of his party with another party. So what is a merger? A merger takes place when two-thirds of the members of a party have agreed to such merger. And the second exemption is if a member, after being elected as a presiding officer of the house, voluntarily gives up the membership of his party or rejoins it after he ceases to hold that office. Next, any question regarding disqualification arising out of defection is to be decided by presiding officer of that house. Also, this is not exempted from judicial review according to Quijotto-Holohan case 1993. Next, the presiding officer of a house is empowered to make rules to give effect to provisions of 10th schedule. According to rules, the presiding officer can take up a defection case only when he receives a complaint from a member of a house. Now let us see some of the provisions of 91st Amendment Act 2003. The total number of ministers, including Prime Minister, in the Central Council of Ministers shall not exceed 15% of total strength of Lok Sabha, according to Article 75. Same is the case with Legislative Assembly of any state. Here, the additional provision is the number of ministers, including CM, in a state shall not be less than 12. Also, a member of either house of state legislature or parliament belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. Now let us see a question based on this. Which one of the following schedules of the Constitution of India contains provisions regarding anti-defection? Second schedule, fifth schedule, 8th schedule and 10th schedule. The answer is D, 10th schedule. Thank you.